right. Good afternoon, everyone. Welcome to our third GDPR webinar in our GDPR webinar series. Today we're going to talk about consent under the GDPR, which is one of the biggest and most important topics we feel. We're going to do things a bit differently today. We originally wanted Alice Lincoln from MediaMath to present this because she's been leading our work internally on this, but she was unable to make it today. So instead, we have Matthias Matthiesen, our Senior Manager for Privacy and Public Policy at IAB Europe, who is also very well-versed on the topic of consent and on the GDPR. So without any further ado, take it away.
Cool. Thank you, Chris. I'll just pull my laptop closer so I know what to talk about. So today's topic is consent under the GDPR. We'll jump straight in. What is consent under the GDPR? It's defined as any freely given, specific, informed, and unambiguous indication of the data subject's wishes, by which he or she, by a statement, and this is important, a clear affirmative action signifies agreement to the processing of personal data relating to him or her. And we're going to go through these various requirements to see how companies in the digital advertising ecosystem can be compliant with these requirements. So the first question, of course, is when does one need consent and when does one not need it? And the GDPR has 6 total grounds for processing personal data, and consent is only one of them. The others are necessity for performance of a contract, necessary for compliance with a legal obligation, you need to protect the vital interests of the data subject or another natural person, maybe the processing is necessary for carrying out a task in the public interest, or the processing is necessary in the pursuit of a legitimate interest, and that legitimate interest is not overridden by the interests and fundamental rights of the data subject whose data are processed. So what that means is that there are alternatives to consent, and all legal grounds are equal. Consent is not king. Consent is also, therefore, not always required. So when you look at your options and you pick a legal ground on the basis of which you want to process personal data, you should undertake a context-specific assessment of the situation, taking into account all relevant rules of the GDPR. But you should also take into account other laws and rules which might influence your choice of legal grounds. And in this context, it's extremely important to bear in mind the rules of the EPrivacy Directive, which you may also know as the Cookie Directive, because that is extremely important for a part of the processing operations that companies in this ecosystem engage in. There may also be other things to consider, such as what type of data you're processing or what type of processing activities you are undertaking, because the GDPR itself may have a different set of legal grounds for different sets of data, such as more sensitive types of data or processing activities which have a higher risk associated to it. So, for example, transferring data into a third country that has not been deemed as offering an adequate level of protection, or making automated decisions which have a significant or similarly, rather a legal effect or a similarly significant effect on data subjects, you may not have some of the legal grounds available to you in that situation. So those are considerations one ought to bear in mind. So I want to take a look at the ePrivacy rules, because when answering the question when consent is required for our industry, one simply shouldn't ignore these rules. And I also want to be clear that we are talking here about the EPrivacy Directive, which is current law in the European Union, and not the ePrivacy regulation, which is a proposed law that is not yet in effect, which will in future replace this ePrivacy Directive. So the ePrivacy Directive applies to the confidentiality of communications, which has a component to it that is the protection of the terminal equipment of a user, which happens to apply to cookies and using other identifiers. So specifically, it says that member states need to make rules that only allow storing information or gaining access to information with the user's consent. So information such as cookies or photos on a computer or a phone or a device identifier, AAID, IDFA, directory data, anything that you can collect that is, if you will, physically on a device requires consent unless you fall into two very narrowly defined exemptions. So for example, if you want to offer a service that is requested by the user, and in order to provide the service, it is strictly technically necessary to access or store information to make provision of the service possible, then you don't need consent. So for example, if you have a shopping cart functionality on a web store that requires storing what is in the shopping cart in a cookie on the user's device, does not require consent. That is an extremely narrow exception though, and the Article 29 Working Party, for example, has taken the view that even service-centric security does not meet that criterion and requires consent, that even frequency capping and advertising fraud prevention does not meet this criterion and requires consent in their view. So just to bear in mind that many of the processing, the data collection that happens in the advertising ecosystem under the ePrivacy rule may require consent. So how does the ePrivacy rule relate to the GDPR? So the ePrivacy Directive does not in itself define consent. It states that consent corresponds to consent in Directive 9546, which is the old data protection directive. The GDPR states that it will repeal the old data protection directive. Makes sense, it is the law replacing it after all. And it also states that all references to the repealed directive will in future be construed as references to the GDPR. So that means on the 25th of May, when the GDPR becomes applicable, the ePrivacy Directive suddenly reads like this. Consent by a user or subscriber corresponds to the data subject's consent as defined in the GDPR. And that is important to bear in mind. So to make this visually more appealing, you have ePrivacy rules that say you need consent as defined by currently the Data Protection Act, the Wettbeschreibung Personengegevens, the Bundesdatenschutzgesetz, a bunch of other European laws, 28 in the European Union plus the EEA, states that are not in the European Union. Now when the GDPR enters into force, all of these laws get replaced by the GDPR, ePrivacy rules remain in place, say you need to get consent as defined by the GDPR. However, the ePrivacy Directive does not regulate exactly the same thing as the GDPR, so only parts of the processing may then fall under the ePrivacy rules and require consent. The ePrivacy applies to the storing and accessing of data on a device, not just personal data, any data, and the GDPR relates to processing of personal data. Now, some of the data you will collect from a device could be personal data, and then clearly those overlap. And then there is a conflict of the rules because collection of data over the internet generally requires consent because of the privacy. And the processing of personal data requires a GDPR legal basis, not necessarily consent. And so which of the two do you apply where both do apply? And the answer is the more specific law. And the more specific law in this situation is the EPrivacy Directive, which means that where you are storing or accessing personal data on a device, you need consent. Now, once you have collected it, in theory, you could start processing it under a different legal basis. The question becomes whether you want to do that. So the first step in obtaining valid consent is making sure the data subject is informed. And the GDPR states that in order for consent to be informed, at least the identity of the controller or controllers and the processing purposes need to be known to the data subject. Moreover, the scope and the consequences of the processing need to be referred to in an intelligible manner. So you need to provide this information in simple terms, if you will. The Article 29 Working Party interprets this requirement as the need to provide accurate and full information of all relevant issues. And the goal, in their view, is making sure that the data subject has an appreciation and an understanding of the facts and implications of their consent. So specifically, you should provide information about the processing prominently and separately from other information. You cannot hide this in the terms of service somewhere in small print. So this needs to be a separate sort of privacy notice, if you will. And, potentially also more prominently in the beginning of processing if you come to a site, for example. You need to use plain language that is easy to understand. So it shouldn't be written for lawyers, it should be written for the data subject, and you shouldn't be using legalese that is not understandable for the average person. It doesn't mean that you can't have legalese text somewhere, but when you present it to the user, you should try and make sure it is understandable by them, since it's them making a decision and they need to be informed. You should describe the nature of the personal data that you're processing. So that might be a random cookie identifier, browsing data, it might be an email address. So if you can describe what you're processing, the data subject will understand what data they're being asked to allow you to process and be informed, therefore. Then describe why you want to process the data. We want to show you more relevant ads. We want to analyze traffic to our website, you name it. There's a number of purposes for which you might want to process data that might be the same in many instances between different companies, or there may be things that only you want to do, just make sure that those are appropriately disclosed. And then explain the consequences of the processing, if there are any. When you consent to this, your data will be processed and the ads you see may be more relevant as a consequence, I suppose. And you want to list, this goes back to sort of this minimum requirement that the GDPR mentions, you need to list the controller or the controllers that will rely on the consent. And you want to do so individually by name. So the UK's ICO has taken a very strong stance on having to disclose the names individually and explicitly, as opposed to having an extremely well-described category of the type of controller that will be relying on the consent. So describing me and my advertising partners will be processing your data is therefore not good enough, because the data subject doesn't know who exactly these controllers will be, and then as a result wouldn't be able to scrutinize that data used, couldn't go and exercise their rights, withdraw consent, and so on and so forth. And you need to inform users of their right to withdraw consent, which they can do at any time, and you need to let them know how they can do so too, so that they can actually exercise it. And then lastly, you want to explain what the consequences are of not consenting, if there are any. So for example, a publisher may choose to reduce the user experience, or simply the user experience is technically contingent on consent, or the user may just simply be prevented from using a service if they refuse to consent, and that should be disclosed to the user when they are being informed about what consent means and for what they are being asked to consent. I think importantly, since this is a lot of information that you should be providing the users, you will be pleased to hear that you don't have to do that in one place the first time that the user comes up to you. You can make use of what is called layered privacy notices, which are particularly appropriate in the digital context because you can very easily send users to the right information, or you can make use of just-in-time notices. There's a number of ways that you can provide notice and in a way that does not overwhelm the user with a wall of text, which they won't be interested maybe in reading, or which is difficult to read in one place. So you want to find a good balance there. So you show the most important information first, and then provide instructions to the user of where to go to find more detailed and more information in separate layers. So one of the things that we said you need to inform users about is the consequence of not consenting. And that sort of relates to this other requirement, which is the consent needs to be freely given. And I think there is a lot of discussion around this particular requirement, and there's also a lot of misunderstanding and, certainly in my opinion, wrong commentary that states that the GDPR prohibits making access to a service conditional on consent. The GDPR does not prohibit making access to a service conditional on consent. What it does do is tell controllers to take into utmost account whether consent is a condition when determining if consent is indeed freely given. And it further elaborates on that requirement in its recital, saying that consent is presumed not to be freely given where it is a condition for accessing a service. We all know that a presumption can be rebutted, which is not the same as a prohibition. So you will have to do some work, and you will have to find a reason why that presumption does not hold true in your case, but you can rebut a presumption. And moreover, the Privacy Directive, which in many situations will be the reason why you rely on consent as opposed to an alternative legal ground, states that access to website content can be made conditional on consent for cookies, which is the opposite of a prohibition. It explicitly allows it. And the Article 29 Working Party, in its interpretation of the EPrivacy Directive, states that as a matter of best practice, they recommend that companies or controllers do not make access to their content conditional on consent, but they do recognize that depending on the member state, they are permitted to do so, stressing that publicly owned government services may have stricter rules to follow, but that companies are permitted to do so in a number of national jurisdictions. So examples are Sweden, Denmark, the Netherlands. There's probably more where you will find there's explicit statements of the regulator saying, yes, you can say your payment for accessing the service is your consent to be to the data processing, in this case, which is required for delivering targeted ads. So I think that's an extremely important thing to bear in mind, not a prohibition, but a requirement to take it into account and to think about whether it's permissible in a specific context. But the next thing, also related to the requirement of whether consent is freely given or not, is the granularity of the consent. So it's very clear that in order for it to be fully informed, you need to separately disclose the various processing purposes. So purpose 1, 2, 3, 4, 5, targeted advertising, analytics, whatever you want to justify with your consent. The GDPR says that where appropriate, the data subject should be able to consent separately to different processing operations. So, for example, you may find that there are things that you can bundle, and there are others that you may not bundle. But what you are permitted to bundle and what you are not permitted to bundle, you need to consider, again, taking into account the context of your offer and your consent request. So where appropriate, you may not bundle. The flip side of the same sort of rule is that where appropriate, you may bundle it. And that might mean that a user is being told, here are the separate purposes for which I want you to give me consent, and you can either consent to all these purposes or to none of them. And that sort of ties back into the previous slide. Are you prohibited from giving them a take it or leave it choice, yes or no? No, you're not prohibited, but you need to take into account what that means for the data subject's sort of ability to freely choose. Now to the scope of the consent. There's a spatial component to it and a temporal component to it. The sort of space component to this is, where is the consent valid? Consent can be obtained by a first party on behalf of themselves and other partners and their partners' partners on a service-specific or a global basis. So service-specific means the scope of the consent is limited to that one service. So you go to Publisher 1 says, me and my partners would like to process your data only on my website or only on my app. Do you consent? And then the user gives consent, and all these companies may then process data to do the purposes on that service. However, there are also, it's also possible for the data subject to allow a given controller to process their data anywhere on the internet, if you will, globally, perhaps even across devices, without limitations, but you would need to make sure that you explain that appropriately. And there too is a lot of question from a lot of people about it, and the Article 29 Working Party has stated that industry claims that having to ask for consent would overwhelm users with consent requests is not true, because if a third-party ad network on one website receives consent for an OBA cookie, this consent will not only be valid on other pages of the same website, but also for other websites that share the same OBA network. So basically, the Article 29 Working Party is saying a third party can carry consent to all of its different clients. And then there's the temporal component to the scope of consent. How long can consent be valid? And again, the GDPR does not contain a time limit, just like it does not contain any specific rule on where consent is valid. And therefore, it is valid as long as it is necessary for the purpose for which consent has been obtained. If you have completed the purpose, logically, the consent would lapse. However, the Article 29 Working Party recommends that you have a justification for why you chose a particular a time period for the validity of consent, and then in any case that it would be good practice to regularly refresh consent or remind data subjects of their possibility to withdraw consent. But there may also be other rules that you want to take into account that de facto require you to do this anyway. So for example, in France, the CNIL states that a tracking cookie may only be stored for 13 months. So its expiry date needs to be 13 months. And so if you need consent for cookies, then and the cookie cannot last longer than 13 months, then logically it follows that you need to reconsent every 13 months. And there may be other considerations that you might want to take into account in different countries, or perhaps even other laws that sort of inform your decision for how long consent is active. This is a new obligation which stems from the accountability principle, which is very important in the GDPR. You must be able, as a controller, to demonstrate that the data subject has consented to the processing of his or her personal data if you use consent as your justification for data processing. So in order for you to be able to demonstrate that your data subject has consented, you need some sort of record, an audit trail, which is kept by both the first party, which is in general the entity that obtains consent, requests and obtains consent, but also by the third party that relies on that consent, because they will have to be able to demonstrate it just the same way. So this sort of requires sharing information through the supply chain. And we recommend that companies consider an automated way of doing so. And in fact, next week we will have a webinar that goes into sort of the technical questions, as IAB Europe has been working on a technical standard that helps with this sharing of information about consent metadata, if you will. So these records should include a timestamp, when has consent been obtained, a URL, where has consent been obtained, what is the action that the data subject has taken to signify their consent, for which purposes has the data subject consented, to which controllers has consent been granted, and also what were they shown, what was the information, the disclosure that has been made to the data subject before they have given consent. And then also, you might want to have an identifier that allows you to connect the record to a particular identifiable or identified user. So that could be a unique cookie ID or email address, or, it doesn't really matter. So you just need to be able to say, if a data subject complains, you have not obtained my consent to do what you've done, you need to be able to say, well, I have this record here that says you actually did, to be able to demonstrate that, or a DPA if a DPA asks. So you also need to allow data subjects to withdraw their consent at any time. And moreover, you need to make sure that revoking consent is as easy as it was to give consent in the first place. So making it very difficult for a data subject to withdraw consent would not be permitted under the GDPR. When a data subject withdraws their consent, that does not affect the validity, the legality of the processing based on that consent before the withdrawal came in. So it's not a retroactive withdrawal of consent, it's forward-looking, which means that you will need a different legal basis or a different set of consent to move forward processing data in the future, or delete the data, or otherwise deal with the fact that you no longer have a legal basis for future processing. And in addition, you should be aware that there are a number of data subject rights which are connected to the withdrawal of consent. That doesn't mean that when you withdraw consent, you automatically exercise these other rights too, but rather that some of the rights are only applicable in situations where the data subject has withdrawn consent. So for example, the right to restrict processing or the right to erase data. It states that where the data subject has withdrawn consent, they may request their data to be deleted too. So those are sort of two different instances, two different rights to be invoked, revoking consent and then follow on rights. So the responsibility of first and third parties. First parties are, of course, best placed and indeed often the only entities that are even able to provide information to users directly because they have the user interface. And so it follows that where third parties and first parties need to make disclosures, it is only the first party that can do so and must do so if it wants to obtain valid consent. And third parties should therefore facilitate that first party partners have the necessary information to make the appropriate disclosures. And they should be aware that even if insufficient disclosures are made and their own processing activities are therefore no longer valid or no longer justified with that consent, the insufficient disclosure of their first-party partner could result in their own noncompliance. So this is something where I believe third parties and first parties will want to work together much more closely than they have in the past. And again, we would recommend that companies consider using automated mechanisms for this, such as IAB Europe's industry consent standard that's been announced 2 weeks ago, and which will be subject to a webinar next week. So then a question is about the affirmative acts that a user can take to signify their consent. Remember, you need a statement or a clear affirmative action. The question is, what is a clear affirmative act? What will meet that threshold? And the Article 29 Working Party takes the view that in principle, there are no limits to what can be an affirmative act. What is important is that there is some sort of active behavior that can be traced by the controller. So if you can detect the behavior, then in principle, that is a behavior that could be used to convey consent. The GDPR has some specific examples, like you're ticking a box or you're choosing technical settings. It also excludes certain things, such as being silent. That's, of course, the opposite of a statement. Pre-ticked boxes and inactivity, which, of course, are the opposite of a clear affirmative act. And this is probably one of the most important changes compared to the old data protection directive, which did not have this clear requirement for an affirmative act. And that means that in many current implementations that are based on so-called implied consent will require changes in future, as it will no longer be possible to infer consent from the fact that a user has not made use of the possibility to refuse consent. So you haven't said no, therefore you have said yes, is no longer an appropriate way of obtaining consent under the GDPR. So that also follows through the EPrivacy rules and sort of the implied consent that is used for cookie consent. So by using this website and not opting out, you are consenting is not good enough. Although there may be different ways that you can obtain an affirmative act that are not as intrusive as a complete interstitial. So you could have what is often referred to as a consent wall, which is an interstitial which you need to take an action before you can even go to the service that you wanted to access, the website you wanted to access, or you could have a banner. And then the question becomes, what is the act? At what point do you know you have consent? Do you need to scroll down the entire page? Could there be something other than clicking on a big green button that conveys consent, after having been provided with all the relevant information? But it's extremely, extremely important that no processing based on consent commences before the consent could actually be registered and recorded. So you need to be able to prove that you've had consent before you start processing based on consent. You can no longer say, I'll start processing and then ask. You ask, then shoot, not the other way around. Legacy consent. So legacy consent is consent that has been obtained before the GDPR enters into force. And as you have now seen, consent was qualitatively different in the past than it will be under the GDPR. However, if you have already obtained consent that meets all of these criteria that the GDPR sets out, then you do not need to obtain new consent once the GDPR enters into force. If your consent does not meet the bar of the GDPR today, you will need to obtain new consent. But the good news here is that you don't have to wait until the 25th of May and then everybody needs to reconsent at the same time. If you're able already to meet these new requirements, you can start reconsenting in line with the GDPR today and ease yourself into the new GDPR regime. And then lastly, you may want to consider how consent is different if you're processing the data of children below the age of 16. Because where an internet service is offered to children below the age of 16, you need parental consent. And you also need to take reasonable steps to validate that consent has indeed been given by the parents. Now, 16 is the default, but member states can adopt laws that reduce this threshold to the age of 13, 14, or 15. So you will have to figure out in the country that the relevant country, what actually is the threshold. Do you need parental consent for 14-year-olds? Maybe not, but you will have to find out. So there's some open questions here, and this is definitely one of the things that we might have to revisit in future. Again, these papers that we published are working papers, that they have to be living documents. Questions like, when is an internet service offered to children? Does the fact that it is accessible by children already mean that it's offered to them, or does it need to be targeted at children? So that obviously would change dramatically what companies would have to do in order to take reasonable steps to validate parental consent. So, general offerings like a news website could be accessed by children below 16, but they're probably not targeted toward children below the age of 16. Perhaps a children's cartoon website might be targeted at children, and there the consideration is entirely different. That's it from me about this paper. You'll see on screen here, and we are sharing this deck with you after the webinar has concluded as well. All of the information I presented is from IAB Europe's consent working paper, which is published on our website with citations to the relevant rules, to guide citations to the relevant opinions from the Article 29 Working Party and other regulatory authorities. So I recommend to read that document. It's I believe 11 pages, so it's not that much reading, although it is quite dense reading. So good weekend reading, in fact. And I also recommend that everybody who has not yet figured out how to manage consent, and I would be surprised for the majority of companies in our industry if they had found a way to comply with this yet. I recommend going to advertisingconsent.eu, where we have a sign up for more information on a technical industry standard that has been developed by the same working group that has developed this consent working paper, and to mark in their calendars the webinar presentation on Friday the 15th of December about this technical standard, or if you are already on your holidays, to find the recording of that webinar down the line.
Okay, thank you very much, Matthias. Something I should mention for those of you who are using the WebEx client for the first time, there's a button in the top right which allows you to type a question to us, and then we can answer that. I'm letting you know this because this is our Q&A section, and we haven't received any questions yet, so maybe it was just very clear and understandable. In terms of general housekeeping, we will be putting the recording of this webinar on our website. And you can also find on our website, as Matthias mentioned, all the papers that we've written so far. We have 3 in total now published, and we're looking to publish more in the future. There will be a sign-up on our website as well for next week's webinar. So, yeah, I just want to make that all clear to you guys, that you can find all of this stuff on our website. I see a question coming in now, but it's still being written. So we'll just wait a little bit until we have some questions to answer.
I'll just make noises for you to know that we're still connected.
Yeah.
I hear in journalism school you learn to describe random objects just so that you can keep talking in downtime such as these.
Okay. So the first question, it's still not complete, but we're getting parts of it. We'll just wait a bit longer. But it's a question which I expected to see. I see the two words legitimate interest, so that's something that we were probably going to have to address. Okay, so the question reads in full: I, as a data processor, can rely, for example, on the legitimate interest in order to process data, but for accessing this data on a device, does the data controller have to get consent?
Yes, that's exactly right. So you have this theoretical...
on your behalf, yeah.
You have this theoretical opportunity to split your legal bases, right? Because the ePrivacy rules and the situation requires consent, does not allow for other legal bases such as legitimate interest or storing the cookie or accessing the information on a device. So you could say, I am asking for consent for storing or accessing information on a device, and then my legal basis for processing is the legitimate interest, and here is my my balancing test, and here's your possibility to opt out, and so on and so forth. My question to those who plan on doing this is, why bother? Because you can say, I need your consent to place cookies or to collect data. Do you agree? Yes. Or, with exactly the same effort, you could say, do you give me your consent to use cookies to collect data and to process it for the following purposes, right? Why you should consider sort of the reason why you would jump through the hassle of doing two things, because a legitimate interest is not a formality, right? It's actually some important work that you need to do to make sure that you meet this balancing test and need to still provide all of these disclosures and so on and so forth. But in theory, yes, you're right, you could do that. There might be reasons because there are certain data subject rights that only apply to where the legal basis is consent. For example, the data portability right does not apply to data that is processed on the basis of a legitimate interest. So you might actually be interested in doing that because of some other considerations.
Okay. I hope that answers your question. I don't see any other questions yet, but there's one question that often comes up when talking about consent as a legal basis, which is it a legal basis which gives you free right to do anything with the person's data once they have consented for your collection? Or are there still limitations to what you can do once you have the consent of the user?
Well, you need to meet the law, right? Like, so that's number one, and then two, once you have the consent, that's for a specific purpose and so on, and you can't really use that consent for anything other than for what you have obtained it, right? Does that answer?
Yeah. No, it's just
question?
a question that I've heard a few times when people hear about this topic for the first time. So in case anyone was wondering that.
So you can't say, do you consent for me to do whatever I want? It's not specific enough.
Okay. We have another question coming in. What time do you think the EPrivacy Directive will be coming into force? I'm going to assume that you meant the EPrivacy regulation, because the EPrivacy Directive has been in force since 2002 and with an opt-in requirement for consent since 2009. But the EPrivacy regulation is a work in progress. It's still an open legislative file that the European Parliament has adopted their position on, but the European Council has not, and we don't expect within the next 6 months that they will. So for it to come into force at the same time as the GDPR, which is the intention of the legislator, is very unlikely, if not pretty much confirmed not to happen.
Yeah, that's correct. So I would like to stress, I'm going to presume that the question comes from somebody who's active in the German market. I'm going to stress that there are consent rules for under the EPrivacy Directive in 27 of 28 European Union member states, and that's all of them except for Germany. So you don't want to ignore the fact that there is an ePrivacy directive already.
Okay, another question's come in. Would it be possible to further discuss the point on consent being a condition for accessing a service? What are good examples of when this might work well?
So I would say that where it works well, and this is really where the discussion, even from regulators under the ePrivacy Directive, this is, if your business model is dependent, your business model and your monetization model depends on your being able to process data, then the service provider should be able to say, I have the service, here are the terms under which you can access the service, and I happen to need your consent to be doing this, so ergo, in order for you to use my service, you need to consent. So private business, where it's a clear value exchange, quid pro quo, you consent because I need this to show you targeted ads, and you get access to the service. I think there it is very clear cut. If you are a government agency, so for example, I'm a German citizen that lives in Brussels, and I needed to get a passport, need to go to the embassy here. In order to make an appointment with my embassy, I need to use their website and make an appointment through some online form. And I needed, and they need to process some of my data, right? They need to write down my name, and so that they can schedule me. It would be inappropriate, in my opinion, for them to say, you can only make an appointment to get your passport if you also agree to us processing your data for some commercial purposes. Like we want to market some new government services to you over the internet, right? That seems to be, because of what's the service I am accessing, be inappropriate.
Okay, another question has come in. What do you think may be an affirmative action besides a click?
Swiping the screen, potentially scrolling down a site, although I think it's harder to see whether that was an unambiguous action. Be interesting to hear sort of what technically can be traced, what kind of actions can be traced, and then also where can one connect that this action sort of relates to a response to the consent request. So clicking, ticking a box, toggling a switch, swiping left or right, up or down, you name it. I think those are the examples that seem already in existence that we use today to indicate that something should happen. I particularly like toggles because they allow very easily to turn on and off, which is withdrawal of consent and granting consent, for example. But I think that we as an industry should consider what type of affirmative actions might be appropriate and what works really well and what is a good user experience, and move toward those. And I'm pretty confident that the market will find some cooler things. There will be some creative approaches to affirmative action.
Okay. We have a follow-up to the earlier question. which asks, will an opt-out for online behavioral advertising be enough until the ePrivacy regulation comes into force?
No.
Yeah.
The answer is no, unless you are in Germany, where the ePrivacy Directive maybe hasn't resulted in a consent requirement. But as I explained, in 27 of the 28 EU member states, you will need to get GDPR consent for the purposes of meeting ePrivacy rules that already are in place. And that goes back to, and I'm sorry, I'm just zipping through, it goes back to this point, where all references to old consent requirements will be replaced with references to GDPR consent requirements.
All right, I think that wraps up our question and answer session. There was just one more question. Is today's presentation available? I'll be sending out a PDF copy of the slides, and you'll be able to find a video of a recording of this webinar on our website in about a few days' time. So with that, I'd like to thank you again, Matthias, for presenting. Thanks everyone for dialing in and listening, and we hope this was helpful. We encourage you to read the paper that we've posted online. It's only 11 pages and goes into much more detail with references and explains our thinking behind consent. So thanks everyone for joining.